This video is to debunk and put the final nail on the coffin, so to speak, on some misconceptions about the age of sexual consent. Misconception number 1. The age of sexual consent starts at 18. Wrong. The age of sexual consent starts at 16 years of age and not 18. The exception is a person 13 years of age or over but under 16 can give sexual consent provided the age difference between the parties is not more than 3 years and the sexual act in question is proven to be consensual, non-abusive, and non-exploitative. My legal basis here is RA 11648, or the law promoting stronger protection against rape, sexual exploitation and abuse, amending for the purpose the revised penal code, and RA 7610. Misconception number 2. The age of sexual consent starts at 18 because it is when a person becomes of legal age. Wrong again. The significance of a person becoming of legal age applies only to his capacity to act with respect to his civil life. It bears no relation with and does not apply to his capacity to give sexual consent under criminal law, which starts at 16 years of age in relation to RA 11648. My legal basis here is the case of Bangayan versus People. Misconception number 3. The term age of sexual consent applies only for purposes of statutory rape. Wrong. The term age of sexual consent applies not just to statutory rape but also to child prostitution and other sexual abuse under Section 5B of RA 7610 and qualified and simple seduction under the revised penal code. My legal basis is, of course, Republic Act 11648. Misconception number 4. The age of sexual consent is 18 pursuant to the Udang case. Wrong. The pronouncement in the Udang case to the effect that a child is presumed by law to be incapable of giving rational consent to any lascivious act or sexual intercourse has been overturned by the en banc decision in People versus Tulagan, whereby the Supreme Court recognized the capacity of a child, now 16 years of age or over but under 18, to give sexual consent. Take note, however, that such consent becomes immaterial when the circumstances of the case fall under child prostitution and other sexual abuse, qualified seduction, and simple seduction. Misconception number 5. The age of sexual consent should be 18 because it is at 18 years old when a person can give sexual consent with no restrictions. Wrong again. The issue under consideration is at what age can a person be allowed to give sexual consent? And the answer is 16. There is no question, and it was never an issue, that a person who is at least 18 can give sexual consent for the simple reason that he or she is no longer a child. Misconception number 6. Pwede na pala tayong makipagtalik sa minor de edad dahil 16 pala ang age of sexual consent. Mali po. Even if the age of sexual consent is 16, you cannot have unbridled sex with a minor. There are laws that protect them from abuse and exploitation like RA 7610 and the Revised Penal Code, as amended of course by RA 11648. Well, you can, but do so at your own risk. Misconception number 7. To insist that the age of sexual consent is 16 is to promote pedophilia and encourage sexual predators to prey on minors. Wrong. To insist that the age of sexual consent is 16 is not a matter of feelings or personal opinion. It is a matter of law. Now, if you are not in favor that the age of sexual consent is 16, then don't attack the messenger. Push your message to your representatives in Congress so that they can amend the law to increase the age of sexual consent to 18.